15 years. She's also a former prosecutor, prosecuted for 10 years. Is a defense attorney now, and she's been board certified in criminal law for over 20 years. So with no further ado, I give you Susan Anderson and Susan Chris.
Welcome. Thank you all for being here today with us. As he told you, my name is Susan Chris, and I'm with the law firm of Chris and Rousseau. I've been a lawyer for almost 30 years. 24 of those years was spent as a prosecutor and as a judge. So I was asked to speak because I have been a prosecutor, a defense attorney, and a judge. And in each one of those positions, I had different ethical obligations and different obligations to the justice system. As a prosecutor, my obligation under the law was not to convict, but to see that justice is done, according to the Texas Code of Criminal Procedure. Sometimes that duty required me to dismiss cases when the evidence showed that a person was not guilty of what they've been accused of. As a judge, my job was to make sure that people had a fair trial, to be the safeguard, to be sure that the rules of evidence and procedure and Constitution were followed, to make sure that I had to rule on balls and strikes without regard to the outcome of the case. And as a judge, tremendous pressure is put on us, I know, as judges, because people want us to safeguard the community. And sometimes when there's a problem with the case, and a judge is required by law to suppress evidence or to let a case be dismissed, the pressure is put on the judge as if it's the judge's fault. And I've lived through that. And I know that when those cases happened and I had to suppress evidence, or I had to dismiss a case because the prosecutor or the police department didn't do everything right, it wasn't on me. It was on the prosecutors, and it was on the police. As a criminal defense lawyer, my obligations are different. I have to protect my client. I have to fight for my client's rights. I have to make sure that all laws and constitutional aspects are protected regarding my client. Now, even though those obligations and ethical duties are all different, they're all very, very, very important. And they're not negotiable. But there are some things that I had to do in common. There are some obligations I had, ethically and otherwise, under the law, that I had to do in each one of those positions. When I became an attorney, I wasn't allowed to practice until I took an oath. When I became a prosecutor, I had to take that oath again, and I had to take it every 4 years. When I became a judge, I also had to take that oath, and I had to take it every 4 years. And the wording varied just a little bit, but basically the oath was to protect and defend the Constitution of the United States. That is the most important job that we all have, regardless of whether we're a judge, a prosecutor, or a defense attorney. That's not negotiable. And you cannot pretend to love the Constitution and to deny any person accused of a crime any protection of that Constitution or of the laws of the state of Texas. That's basic law in every courtroom in this country. Now, what are we here today for? Let me just tell you that the district attorney is very concerned about whether any laws regarding the things that we can say to the press are followed. And there are ethical obligations that all lawyers have regarding litigation, so that cases are not tried in front of the press. However, it is important that the press participate in the process to see that justice is done, to be there for the community so that the community knows what happens in the system, to be there to make sure that all of those ethical obligations I outlined above are met and followed. So your role is also very, very important. But we have rules, and there's things that we can say, and there's times that we can say, and there's things that we can't say. And none of us here have any intention of violating those rules, so the district attorney need not be concerned. We are not going to try our cases in the press, but we do want the press to be involved in the system. We want you to be involved in the investigation and involved in the prosecution of these cases so that everyone in Texas and in the United States sees what is going on here and what has happened and whether all of these persons who are accused have their constitutional rights protected or violated. Your role is going to be very, very important. It's going to be challenging because of the volume. But that's what makes our jobs more fun, I think, on your end and our end. Let me tell you what we're not here to do. We're not here to talk about our individual cases for the reasons that I've outlined above. We're not here to try any of them, and to tell you the truth, there's too many of them to talk about right now. It wouldn't be doing them justice to give them each about 5 minutes coverage. Their stories will be told, and they will be told in full. And each one of those individual stories, which are individual, will be played out in a courtroom at some time if the prosecution proceeds with trying all of them. We want their stories to be told, and we want you to cover them. We're not in a position to talk about them today. We are here for other reasons. We're here to talk about the process. And we are here to work together on the parts of the case that we can work. Some of our ethical obligations will require us not to reveal information to each other because of the attorney-client privilege. But there are some things that are common because, to be honest with you, there's too much in this case that's too common. The actual accusations and the bonds and certain parts of this are way too common. And that's going to require that we work together on the parts that we can in order to see that justice is done. This case is different in the sense that it's a mass litigation case. And as a judge, I handled some of the biggest mass litigation cases in Texas. I handled the BP explosion in Texas City. I handled the Ike insurance cases. And those cases present certain challenges. It's very, very rare to have a criminal prosecution that's mass litigation. But one thing that is very, very important, regardless of what process you come up with to do that, to see that justice is not delayed, you can never sacrifice justice for expediency. We are here today to work together to make sure that that does not happen and that our clients' rights are all protected. With that, my friend Susan Anderson is going to talk to you a little bit more about the process.
Thank you, Susan. What I want to talk to you a little bit about is what is supposed to happen in criminal cases and how things were handled in the Twin Peaks cases. Now, normally before the process even begins, over in the courts, someone is arrested. Now, in order to have an arrest and in order for a warrant to be issued, you must have probable cause. You must have some evidence that a crime had been committed. But not just probable cause, you have to have individualized probable cause. That means every person arrested must be connected in some way other than merely being present. And we know in this case, 177 people were arrested. And we know in this case, those arrest warrants were fill in the blank. They were identical. In those arrest warrants that are public record, there was no individualized probable cause. And those arrest warrants, every single word is the same, but for the person's name. So in these cases, we had fill in the blank arrest warrants. But it doesn't just stop there when we start talking about individualized probable cause and how you connect people to cases and whatnot. Once a person is arrested, a bond is set after arraignment. Now, what is the purpose of a bond? A purpose of a bond is really just a measurement of risk. Whether or not this person is a danger to society, whether or not this person can give proper assurances that they will return to court. What a bond cannot be is punitive in nature. We know that in this case, every single person arrested was arraigned, and every single bond that was set was the same, at $1 million. It doesn't sound like there was any individualized assessment of the persons involved in that. And it certainly sounds like it was punitive in nature. Now, after the bond is set and after arraignment, what happens to a case? A case is handled by the district attorney's office, and the district attorney's office refers those cases to the grand jury. Now, the DA controls the grand jury process. They meet in secret in the DA's office. It's important that you realize that the rules of evidence do not apply in a grand jury hearing. So you can have hearsay, you can have hearsay upon hearsay, you can have hearsay upon hearsay upon hearsay. In fact, the DAs are not even legally required to submit to the grand jury any exculpatory evidence. They control what is presented to the grand jury. There is very limited involvement on the part of the defense. When an indictment is returned, Again, it must be based on individualized probable cause. What do we know now? We know that the grand jury, which met in secret, according to the DA's office, they said they had a marathon grand jury session for 9 hours. After that 9 hours, 106 indictments were handed down. 106 indictments over a period of 9 hours. If you do the math, if the state, or if the grand jury did not take any breaks, did not go to the bathroom, did not have lunch, has worked from 9 until 6, that averages out to 5 minutes, 9 seconds per indictment. Now, when you submit evidence to the grand jury for an indictment, again, it must be individualized. You are not supposed to submit en masse, because for an indictment, it must be for the person, not for a group, not for anything else, but for the person. And that's one of the problems that we have in this case, is the lack of individualized attention at the arrest, at the bond, and now at the grand jury. And one of the reasons we're all here today is to show you and to tell the community and to tell the DA in particular that this is where the rubber stamp meets the road. Now that the indictments have been handed down, now we can get into the fun aspect of our cases, and we'll be able to show just how mishandled these cases have been from the get-go. And I'm going to turn everything over to Susan to talk about the elements of the offense that the DAs must prove in these cases.
As Susan said, the indictments being released sort of starts some of the work that we have to do. There's some things that we can't do until that happens. So now that that happens, we have the written accusation that will be presented at trial. The way the system works is, when we get to trial in front of the jury, the DA is required by law to prove the elements of the crime. And in this case, it's all the same. They're going to have to prove that there was a conspiracy to commit a crime, namely murder or aggravated assault. Conspiracy is